started. All right.
Mr. Chief Justice, may I sit during his Mr. Mann's argument?
Yes, Josh, just make yourself comfortable, and please make sure that you mute yourself during Mr. Mann's presentation.
Yes, sir.
All right, let me record to the cloud here, and then we are going to be all set. All right, gentlemen, counsels, we are going to ready now. And so will the clerk please call the case?
This is Supreme Court case number CRA19-023 in the name of Western Sales Trading Company, petitioner appellee versus GenPro International Inc., Guam, respondent appellant, and FD Food International Inc., aka 7D Food International Inc., real party in interest. Western Sales Trading Company, petitioner appellee, is represented by attorney Joshua D. Walsh. The respondent appellant, GenPro International Inc., Guam, is represented by attorney Bill R. Mann. Attorney Mann reserves 10 minutes for rebuttal.
Thank you, counsels, and welcome to our virtual Supreme Court appellate arguments. On behalf of my colleagues, Justice Merriman and Justice Pro Tem Joseph Camacho, we thank you for your participation in our oral arguments via our video conference technology. And as we experienced very briefly, while it provides us the convenience of continuing our work in the court, there are also challenges with technology at times, and we just have to work through those issues. As indicated earlier, a little different from how we argue the cases in the courtroom in presence is that each counsel will have 5 uninterrupted minutes at the beginning of their arguments before any of the justices are allowed to ask their questions. And so with that, we will begin, and Mr. Mann, please proceed. You're going to have to unmute yourself, Bill.
Yes.
All right. Like we said, we have some challenges with technology, and we even hear every knocking, but you may proceed.
Mr. Chief Justice, and may it please the court. The appellant, GenPro International Inc., is a Guam business which imports products from the Philippines for resale to retail outlets on Guam. One product it imports is a packaged dried mango product known as 7D dried mangoes. The appellee, Western Sales Trading Company, is another Guam company that imports a different brand of dried mangoes from the Philippines and competes directly with GenPro in the sale of dried mangoes on Guam. GenPro acquires its dried mango product from FPD Food International in the Philippines, which, according to the trial court, is a successor corporation to 7D Food International Inc. Now, GenPro was ordered by the Superior Court to turn over to Western Sales all of the dried mango product it purchased from either FPD Food or 7D Food. This is a physical taking of GenPro's private property. There are a whole host of organic act and constitutional problems with this taking of GenPro's dried mangoes. The simplest and most apparent is that just compensation must be paid for the taking. Just compensation in the circumstances of this case is fair market value, namely what a willing buyer would pay a willing seller for the mango product. This case that was submitted is especially simple since we know what the fair market value is here, namely the amount for which Genpro sells its dried mango product to its retail customers on Guam in the normal course of its business. However, the statute in question, 7 GCA section 23401 et sec, which was enacted in February 2018, and which I will refer to as the turnover statute, does not require the payment of fair market value, but only grants a lien to the condomnee, here Genpro, in the amount of the condomnee's cost in the product. The problem is that the condomnee's cost in acquiring the asset under the law is not even relevant to the determination of just compensation, much less determinant. This is a specific holding of a U.S. Supreme Court case, Olson versus United States, which I discuss in the briefs. This court need go no further. The turnover statute is inorganic and unconstitutional on its face by limiting the condomnee's compensation to the condomnee's cost in acquiring the asset taken as opposed to fair market value. But that is not the only problem with this strange statute. There is no assurance that the condomnee will actually receive even its cost in the asset taken. In the statute, all the condomnee gets is a lien for its cost in acquiring the asset, which lien is not paid unless and until the judgment creditor sells the asset. Now, I discussed the U.S. Supreme Court case, Williamson County, in the brief. Under that case, it is true that cash need not be paid at the time of the taking, but only if there is a certain and adequate provision for obtaining compensation. Here, the statute does not explicitly require that the condemned assets be sold, much less set any time for their sale. And what if the amount realized at a sale is less than the condomnee's cost? Then what? The turnover statute flunks miserably the requirement that there be a certain and adequate provision for the payment of just compensation, and is inorganic and unconstitutional for this reason also. Now, as if that were not enough, the statute...
So Mr. Mann, before you move on from the just compensation, and we're reaching the 5-minute mark, I realized. If we were to, first of all, let me ask the question, who makes the determination as to just compensation? And is it the legislature or the judiciary? In a takings, in a public condemnation proceeding, assuming this is subject to the takings clause?
Well, the judicial branch makes a decision as to what constitutes just compensation. And the general rule is very simple: market value. There are some complex, exceptional cases where other measures are used, but in the typical compensation case, for example, a land compensation case, it's simply market value of the asset taken. That is a judicial determination always.
So is it necessary to strike down the statute, since the principle that we strive to uphold the constitutionality of the statute if we can? And if it is the judiciary that makes the determination, and the case, we've pronounced that in the, it's an odd title of a case, 162.40 square meters of land, but I think both councils know which case I'm referring to, a Guam Supreme Court case, that it's a judicial determination that determines just compensation, and not necessarily the legislature. So if we were to strike down that specific provision that costs the value is determined by the costs to the person subject to the turnover order, and instead have the judge make that determination, which you argue includes profit and interest. Is it necessary to strike down the statute?
Yes, Your Honor, it would be, because the statute is unconstitutional on its face in setting the just compensation at cost as opposed to market value, when the case law is quite uniform in saying that the just compensation in this case has got to be market value.
But that's my point. If we say, based on our precedent, that it's the judiciary that determines what is just compensation, and so we strike down that provision that sets it at cost, and if assuming that's a severable action, and it is the judge that makes that determination, and the remedy then is to remand back to the trial court to determine just compensation, to include, assuming we agree, your lost profits and interest. Why wouldn't that be an appropriate remedy in this case?
I fear that remand would be inconsistent with the language of the statute itself, which specifies cost. I don't, there would actually be, I'd respectfully submit, the court's attempt to rewrite the statute. The statute is clear enough, it's the cost. And to remand to say, no, don't follow the statute, follow the Fifth Amendment and the Organic Act and set just compensation and market value would be just entirely inconsistent with the statute. That's why we argue the statute was facially violates the Organic Act and the Constitution.
So you don't think it would be within our authority in applying principles that we have announced in prior cases in determining just compensation as an area for the judiciary to determine, and not necessarily be restricted to what the legislature pronounces is what is just compensation, that we would be stepping out of our authority to do that, and that's not within our discretion to exercise?
What I would say, Your Honor, is if a statute merely provided that just compensation shall be provided by for the taking, and then there's a debate as to how to calculate just compensation in the Superior Court. Certainly this court could say, no, here is how it needs to be calculated. However, the problem here is the statute itself defines just compensation as the condominium's cost in the product. And so it's not for this court to say, well, we believe in order to be constitutional, in order to uphold the statute, the Superior Court must award compensation based on market value. And I don't know. I don't believe this court would really be able to do that, because that would be, in essence, rewriting the statute. This is simply a statute that is unconstitutional on its face, cannot be saved, and I don't believe that part of the statute can be severed, because that's essentially what the statute is all about. I might add that if the statute required just compensation as defined by the market value of the product taken, there would be no reason for anyone to ever use this statute. This wouldn't make any sense.
I'm sorry, you faded there at the very end. What was that last part? That statute would not be workable? Is that the
if the statute itself said, okay, the dried mangoes could be taken by Western Sales, but it must pay the market value of the dried mangoes, which is what Genpro sells to its retail customers. There would really be no reason for Western Sales to bring a proceeding under this statute, because it would simply be buying the mangoes, and Genpro would make its normal profit, and of course they have a lot of expenses to cover. but there would be no reason for Western Sales or any other judgment creditor to use the statute in those circumstances.
But really, that's not of concern to you, so long as your client is made whole.
Well, yeah, that would be an easy way for my client to make money, because they just order and it's condemned, and then Western Sales get the product. However, that would just go into the problem of, is this a public use? When, my client has to turn over its dried mangoes to another party. What is the public use? And that's my second grounds for objecting to the statute. Well, actually, to complete the first grounds, there's no interest under both Guam law and federal law. After a taking, if the money is not paid in cash right away, the condemnee must constitutionally receive post-taking interest. And in the 162.4 square meter case that you're going to refer to, compound interest is actually required post-taking. And of course, this statute itself makes no provision for post-taking judgment at all. And so yet that's a third reason why the statute fails to provide just compensation before we even go into the issue of, is this a public use?
But then again, if it is within the authority of the judiciary to determine what just compensation means, couldn't the trial judge then, in making a determination of what just compensation is, and it's that is within its scope of authority, include interest? And wouldn't that be consistent with our 162.40 Supreme Court case in providing what just compensation is, and it can include interest and even determine what is a reasonable rate of interest?
That is correct, Your Honor. Then that would make the statute constitutional, no problem. But it would also be really a complete rewriting of the statute, because the statute doesn't provide for interest. It doesn't provide for any certainty regarding when the product would be sold or what happens if the sale produces less than the cost, and it explicitly requires cost. So it would be more than this court saying the trial court made an error in calculating the amount of just compensation. The trial court followed the statute and used, over our Genpro's objection, used the cost of Genpro, even though we argued that it was unconstitutional. So my suggestion to the court is respectfully that would be rewriting the statute. This is not a case where there was just an error on the part of the trial court in applying the statute. The trial court applied the statute as written. The trial court did not err in applying the statute. The trial court erred in not holding the statute unconstitutional.
Great.
Okay, just briefly then, it is Genpro's position that this taking was not for public use. The whole point of the statute is to take the private property bay and give it to B. In the case of Kelo versus New London, a U.S. Supreme Court case I discussed in the brief, the city of New London did take A's land and give it and lease it to B so that B could upgrade the land as part of an urban renewal plan. But in that case, the property taken, the land, benefited the general public by being upgraded. Now, Western Sales here has not suggested it'll donate the mangoes to charity, and the mangoes in the hands of Western Sales serve no public benefit, but only the private benefit of Western Sales. Now, it is true that private property may be taken from A and given to B, but only when a broad public benefit justifies the taking. The Guam legislature stated the purpose of the turnover statute is to protect the people of Guam from foreign judgment debtors who do business on Guam but fail to pay the debts against them, the judgments against them. Now, no doubt, this benefits the very narrow class of Guam residents or entities who hold unsatisfied judgments against foreign entities. But where is the broad public benefit necessary to take A's property and give it to B? The broad public benefit simply does not exist here, at least not to the extent necessary to justify the taking. In this case, those Guam consumers who prefer the 7B brand of dried mangoes are denied their choice. But more importantly and more broadly, the turnover statute repeals Guam UCC sections 2401 and 2402 without saying so. Those sections of the UCC are important in that they provide assurance to a buyer of goods who has paid for the goods that the goods will not be subject to judgments against its seller. I provided various examples in the brief of how this could be disastrous to Guam buyers of goods. In summary, this statute is unique. In the Cabo case, no one said that the public renewal was a bad idea. The spirited dissent just objected on constitutional grounds. And so, if you look at the condemnation cases and cases in this area, no one is really saying that it's a bad idea that this private property be used a different way in someone else's hand when it's given from A to B. But what the courts place limits on that when the private interests dominate. I submit, Genpro submits, this statute is truly unique in that the statute itself is detrimental to the public interest by repealing the UCC, and on the one hand, having a broad public detriment, on the other hand, only benefiting a very narrow class of people. And because of that, once again, Genpro believes the statute is inorganic and unconstitutional. And then finally, it is the third ground. It is clear as the trial court found the statute impaired, even nullified in the trial court's language, which is correct, the contract between Genpro and FPD Food. Now, this impairment of contract is permitted only if there is a significant and legitimate public purpose as justification for the impairment. And for the reasons I discussed here and in the brief, the statute does not have a sufficient public purpose to justify destroying the contract between Genpro and FPD Food.
So you don't feel that the court, as you've pointed out, I mean, the legislature made the pronouncements in reference to the purpose of the statute. And normally this court gives great deference to the legislative branch in reference to its intentions and the purposes of public policy that's prescribed. And so you don't feel that this court should provide that deference and an expression that it wishes to allow for a business environment that protects local businesses and who's obtained judgment against foreign creditors instead of incurring the expense of trying to execute in a foreign land?
Yes, Your Honor. Normally, the Supreme Court would defer to the legislature's decision as to what is appropriate justification for a statute, including a taking statute such as this. But there is a constitutional and organic limit to that. And the cases are clear. Yes, you can take property from A and give it to B, but there must be a broad public purpose to justify that. And that is the constitutional requirement. So it does place this court in the position of determining whether or not benefiting a very narrow class of people, the people who have unsatisfied judgments against foreign creditors, benefiting those people is when that's balanced against the harm of the statute, such as the effect on the UCC, this court can say no. This statute does not, we cannot accept the legislature's statement without considering the other effects of the statute, because it is the burden of this court to say whether or not there is a sufficiently broad public interest to justify either the taking for a public, whether it's for a public purpose, and whether it justifies the impairment of the contract. And that is the burden I would respectfully submit of this court.
I see you've entered into your reserve time, but I'm going to ask my colleagues if they have any questions of you before we turn it over to Attorney Walsh. Justice Merriman?
Mr. Mann, if I go to Kmart and buy one of these packages of mangoes, as I read the statute, then they could come and take my mangoes away from me as I walk out the door.
You
Do you
mean,
think it's that extreme?
Your Honor, as a consumer?
Right.
Oh, I
If
don't
you're
think
saying
that's
the
the case.
UCC doesn't apply, then if I have the asset, it can be seized from me, right? Or do you think it's that extreme?
Well, I seriously doubt that Western Sales would want to take the mangoes away from Your Honor. I hadn't thought of that. I get, theoretically, they could take it away from you as long as they paid you whatever you paid, Kmart or Payless or wherever you bought it. Theoretically, I guess they could. Not that they would, but I guess they could.
And then with respect to the contracts issue, does it just abrogate that one contract, or does it abrogate GenPro's contracts with businesses that it supplies goods to?
To my knowledge, GenPro doesn't have a requirement, to supply Kmart and its retail outlets with this. Its contract that we're referring to, which was abrogated or impaired, was with FPD Food in the Philippines.
Okay, thank you. That's all, thank you. Justice Carbolito, you're muted.
You're right. Justice Camacho, do you have any questions?
Just a couple of clarifications to Mr. Mann. You were talking about broad, like how broad is broad? Isn't it a segment of if the legislature already spoke, the Guam legislature already spoke that at least this segment in our community, parties or commercial parties or business entities, isn't that enough? The question is, how broad is broad? Do you want the legislature to say that it serves a public purpose?
How broad does the public purpose have to be? There has to be a definite benefit to the public. And maybe broad is not the best word to use. I cited an Illinois Supreme Court case, which I thought was instructive on the concept of public use, where it related to expanding a parking lot, which the court said this is a good idea in the sense that it would increase safety of pedestrians, reduce congestion, but it was the racetrack actually that would benefit most. It's mainly a private benefit, and because of that, it was determined that taking was determined to be unconstitutional. So I think when you look at the broad public benefit, you need to look. I mean, who is really benefiting here? Is it a private interest or is it truly a public interest? And there can be a balancing approach even. And in this particular case, when we look at all the detriments to this statute, my GenPro's position is we subtract that from whatever benefit there is. And the only benefit is to a very narrow class of people who have judgments against foreign entities on Guam. And it's not a lot of people, I would submit, that benefits, whereas there's a lot of people that this statute can harm. And that's the reason I say there's insufficient broad public interest.
Mr. Mann, going back, you mentioned this a little bit about the government for public purpose or a government actor, right? Do you need the government to come forfeit a property, real estate, for example, or any number of property? But do you need a government actor to be involved, or can private entities be, touched upon the takings clause?
No, this is obviously in some taking cases, it's the government itself that takes the property, use of a school or road or whatever. But in other cases, like the Kilo versus City of New London case, the government's role is to pass a statute, and then the court in a condemnation case will literally take the property A and in that case lease it to B. And the government did not end up with the property in the Kalo case or other cases, other of the urban renewal cases, which then generate controversy about taking property from A and giving it to B. So it's not necessary that the property end up in the hands of the government for it to be a taking and for it to raise constitutional issues.
Thank you very much, CJ.
All right. Thank you, Mr. Mann. And so we will allow you to reserve your remaining time. And at this time, the court recognizes Attorney Joshua Walsh.
Thank you, Mr. Chief Justice, and may it please the court. I'll start off with just giving the court a little bit of warning. I'm having some trouble with internet in our part of Agana here, so I fear I may be the first attorney appearing in this new age of COVID who will have to phone in. If that happens, I apologize to the court.
Thank you.
When an appellant like Genpro seeks, in a judgmentless case, appellate review of the contents of a particular decision in order, 30 days after that decision is entered on the record, that appeal is out of time and this court lacks jurisdiction to hear it if it's seeking an appeal beyond that 30 days. Furthermore, when an appellant like Genpro is commanded to turn over assets pursuant to a law drafted by a legislative body, exercising its general welfare police powers, and that law is built upon sound public purposes, and the appellant is made financially whole by turning over those assets by receiving everything that they are entitled to in terms of a fair market value, there is no offense to the federal constitution, no offense to the Guam Organic Act, and Genpro's appeal should be dismissed. I'd like to first just touch on briefly this jurisdictional issue that we raised in our briefs, because that's as this court does, it reflects on the jurisdiction first. And we know from Seifrid that the rules 3 and 4, which are the jurisdictional rule gateway to this court, are mandatory. They're not waivable. We also know from Moylan that that this court disfavors seeking exceptions to the jurisdictional rules. And I think the docket here tells the story of why Genpro's appeal is out of time. The petition in this case was filed on April 10th, 2018. On May 11th, 2018, and we can see this at our supplemental excerpts of records at 8, on May 11th, 2018, the Superior Court issues a turnover order. It says, turn over the assets, or the alternative, show up to the Superior Court to show cause why you needn't turn over those assets. So there is an order that says turn over or come to court to show cause. From June onward, there is a show cause effort, and that show cause effort ultimately fails when on April 26, 2019, the Superior Court of Guam makes a decision and says, no, Genpro, you have not shown cause. The issues that you raised, the lack of a constitutional basis for the statute, the lack of an organic basis for the statute, those issues raised were dealt with. Genpro didn't show cause. So therefore, the position that Wesco advances here is that the combination of the April 26, 2019 decision and order with the May 11th order to show cause, the turnover order, that completed this case. And when this case did not have a judgment, and Genpro made a decision to move forward with an appeal without a Rule 58 separate document, that doing so in October was out of time. There are some ancillary issues that get dealt with in the case following the April 26, 2019 decision and order. Those ancillary issues included an effort for fees and costs. Eventually, there was a contempt motion drafted. The Genpro filed a de facto supersedious bond effort on May 28, 2019. Genpro in that filing said we intend to appeal. There were other issues, including what the amount of the supersedious bond that eventually was allowed in this case in October 29th, 2019. There were those issues that were dealt with, but nothing after April 26, 2019 dealt with the issues that are on appeal today. The issues of the constitutional nature of the statute in question or the Organic Act, passing muster under the Organic Act. Those issues were dealt with completely in April 26, 2019, and they can't be resurrected simply because Genpro decided to file a notice of appeal within 30 days of an October 2019 decision and order. This result would not be unusual. This court, as we know from its decision and order in UJOA, this court said in a judgmentless case, as was UJOA, that this court was not going to extend its jurisdictional basis to review in the UJOA case an earlier decision and order to have that bootstrapped into a later in time decision and order. So we think based on UJOA, we think based on this court's jurisprudence in Wise Owl, the adoption of the malice rule, we don't think saves the issue here. We think Genpro's out of time because we think the totality of the April 26th decision and order, coupled with the turnover order that was issued in May, made a 30-day clock start to run on Genpro at that time. So we think that Genpro is out of time. And of course, I'd address any questions the court has about that when the court wants to ask me. I'd like now to address the actual merits of this case, the constitutional law issues that are here. And I think it's important to start off with the idea that, yes, we are in a de novo review situation because
But
Genpro
before
has
you proceed, since you raised the jurisdiction issue, and I didn't seem to have any issue, but why doesn't the 150-day rule work to such that final judgment entered after the two orders that you had pointed out? And since there's no separate document, why doesn't the 150-day rule, which would then have it expire within the time frame in which the notice of appeal was lodged, why doesn't that then allow the court to have jurisdiction in this case?
Yeah, I think the Ninth Circuit called this the thorny thicket issue, this idea of the constructive judgment under Rule 58. I don't think that the Rule 58 constructive judgment that gets issued 150 days after the decision and order saves this case, because in the cases that Genpro stands upon, Ford and Long, in all of those cases, even in Wise Owl before this court, the appellant that was seeking review checked two boxes. There was the first box of being timely under Rule 4, within 30 days of the particular order or writ or item that they were seeking review of. The second box, the Rule 58 box, is checked simply to solve this issue that existed previously about whether or not we had a separate document. But Rule 58 is not the jurisdictional basis for the case. All Rule 58 does is prevents somebody from using the lack of a separate judgment as a sword to cut off jurisdiction. We don't have a separate judgment, so yes, I understand that the box can be checked to say that a constructive judgment was issued. But Genpro made a decision to not await a judgment, to take the position that there would be no judgment coming. And Genpro then puts itself in, I think, the same situation of a UJOA litigant, where the litigant makes a decision, I'm going to file an appeal that takes me down the pathway to the left, but the pathway to the left takes me down a pathway where I should have appealed within 30 days of the actual decision and order I'm seeking review of. So I think it's a twofold analysis there, Mr. Chief Justice. It's Rule 58 operates to check the box for the constructive judgment, but Rule 4 still says you need to be timely within the judgment. It doesn't say constructive judgment, and must be timely within the order that finally disposes of the case. And we think that was the April 26th decision and order.
Yeah, I suggest we proceed to the merits and
Yes, sir. So as I was saying, we are in a de novo review situation. This court obviously has its powers to review de novo the statutes that are put to it for review. But I think as you, Mr. Chief Justice, noted earlier, this attack being raised by Genpro is a facial challenge. Mr. Matt acknowledges this. This is a facial challenge, and as we know from Salerno, a facial challenge is the most difficult challenge to mount successfully, because the challenger must show that this statute cannot withstand any scrutiny. This statute will have to, there's no application of the statute that makes sense at all. And that simply is not the case. So while we are in de novo review, Genpro is not appealing the October decision and order on the nickels and dimes or the particularities of whether it had its just compensation. Genpro's attack is a facial one. Genpro urges this court to say that the statute in no circumstances can stand. In no circumstances can stand. And we know that that simply just isn't the case, because if Genpro had simply been given the number that it wanted, Mr. Bowie's, I think, declaration said that he was entitled to a certain amount of money under the lien. If he had that number instead of a lower number, there'd be no basis for picking a fight over that issue. So the attack here is a facial challenge, and as a facial challenge, I think that just is the easiest way to dispose of this, because there are numerous situations where you could imagine a trial court judge exercising the trial court's ability to call balls and strikes on what a just compensation number would be, would have given a number that would have angered, I suppose, the petitioner, Wesco in this case, and satisfied Genpro. But that's not the issue on appeal today. The issue is whether or not this statute passes constitutional muster in any scenario, and it certainly does. Genpro's biggest complaint here, the appellant's biggest complaint, is that somehow the concept of just compensation includes a guaranteed profit. And because it did not get its guaranteed profit in the lien that was issued here, because it was not given its guaranteed profit, that this statute somehow fails. There is no law that says that in takings jurisprudence, just compensation means guaranteed profit. The framers wrote the phrase just compensation. The writers of our Organic Act said just compensation. Trial courts, I think, as you recognize, Mr. Chief Justice, trial courts have that ability to figure out what is just. And in this case, we have just compensation. While GenPro may not be given a guaranteed profit, there's no question that GenPro is being made, as Olson says, financially whole here. Olson language. It is GenPro would be entitled to be put in as good a position pecuniarily as if his property had not been taken. He must be made whole, but is not entitled to more. Not entitled here.
Isn't that the argument, though, Mr. Walsh, that the standards that the party whose property is seized must be made whole, and in trying to provide some type of formula to what just compensation, market value, someone in the court trying to determine what does it mean to make someone whole and be put in as good position as if the property had not been taken. And so in this particular case, the argument is that GenPro thought that when it purchased the property and it was going to resell it, that its profits would have been realized. And so isn't the expectation that in order to be made whole, that it would include more than just your costs? Because no one purchases in the retail business to recover their costs only. I mean, that's just not what market value means to any particular businessman. So if we were to try and give substance to the principle, what does it mean to be made whole? Are we necessarily limited to just the cost of what a party purchases a property for?
No, of course not, Mr. Chief Justice, but I'd say two things on that. First is I'd say even this concept of cost, as we know from just litigation in the Superior Court of Guam, the question of cost does have a formula, but it's still applied by a trial court judge. So if after a case I'm victorious, I seek my cost, a trial court judge is going to have, a trial court judge will have precedent from an appellate court, but would say, well, yes, your check translator is an appropriate cost, or this is too many photocopies, or I like your Westlaw charges, but not your Lexus charges. There's a formula and there's guidance. I agree completely with that. But the second thing I'd add, Mr. Chief Justice, is that this is not that case. GenPro is not appealing the October decision and order that said, this is the formula I am applying, and GenPro saying the formula got applied wrong. GenPro's not doing that. What GenPro is doing is appealing the April 26th decision and order that said this statute in all phases is unconstitutional. Right? Not the formula that Judge Sokola applied, but saying that this statute doesn't have a mechanism at all that could have any formula applied to that. And I just think that's not the case. The legislature said the party is entitled to their costs in acquiring. Costs in acquiring. Those three words, I think, just speak to needing a trial court judge to come up with these ideas. But to say that the idea of costs in acquiring could never be just compensation, or that costs in acquiring could never have some sort of amount beyond just what you paid your product supplier for it, is just not, just not the case, and not what's actually on appeal here, sir. What's on appeal here is that this statute and the costs in acquiring, it could never be just. And I don't think that's the case. I certainly recognize that in takings cases, there are certain takings cases where some litigant could make the argument that says my making whole costs includes some modicum of profit. I suppose if I had a contract for the next day's sale. But I think the reason that no case has been cited by GenPro to this court that says I'm entitled to my profit, it just broadly is because there is no pro forma case that says that. You're entitled to just compensation under Olson. Trial court judges make those determinations. The trial court judge here made a determination, but that's not on appeal. What GenPro is saying is the statute fails in every regard.
Well, I don't necessarily know. I don't know necessarily if that GenPro's appeal is as restricted as you characterize it, because if the 150-day rule comes into effect, there's a judgment. Any appeal from a judgment includes all the orders that are included within the scope of that judgment. So I'm not necessarily seeing it that it's only restricted as that you characterize it. And so assuming that it's not as restricted, the issue in the just compensation has reference to, and both parties cite cases that, and Mr. Mann cites cases that stand for the proposition that the party, his client, is entitled to be made whole. And so if we then look at, and that's, you know, what, that is the issue before the court, is GenPro made whole as a result of only recovering the costs and not, and even say for the interest is not even included in that, and according to Mr. Mann's arguments.
I recognize it, and I think if I could imagine the Superior Court guidance on this.
Mr. Walsh, you are freezing up, and so we'll just be a little patient here in reference to allowing your internet to kick in.
Thank you. I hope this is better.
Yes, it is.
I could imagine the Superior Court welcoming any guidance on what this court would like to lay down as a formula for just compensation. This court has done that, though, in 162 square meters. You know, we've got some guidance, and the Superior Court has guidance on what just compensation could be. This court could provide guidance the legislature meant when of costs in acquiring. I think this court could certainly do that. But I'd also offer one other point here is, I think since if this is a de novo review where the court is going to review everything, I suppose the first question is this even a taking? I'd offer briefly, if I could, just this statute appears in Title VII's judgment collection statutes. We know from the statutory construction instructions from this court that we look to statutes, we look to the neighbors of statutes to find what these statutes do. I don't see an exercise of eminent domain powers here. What I see is the legislature providing a judgment collection mechanism similar to sort of for foreclosure proceeding. You know, I think as Justice Camacho recognized, even in the foreclosure proceedings, there are foreclosure proceedings where a bank moves for foreclosure against a home title owner, even though that home title owner is not the mortgagor, right? So while I understand that Judge Sokola, I fully recognize that the judge said that we're going to do a takings analysis here and that this is a taking. I would just suggest that perhaps this isn't even a taking, because this is simply just the exercise of police powers and general welfare powers by the state to create a statute to aid in furtherance of judgment collection. And it lies squarely there in Title VII's judgment collection statute regime. So I don't think it is a taking. But even if it is a taking, is there just compensation paid? We think that there was. If this court wants to provide guidance to the Superior Court about what just compensation in the context of this statute should be, I think that's fine. I think the court obviously can do that.
I think we lost Mr. Walsh again there momentarily, so we'll allow his internet to activate.
I think we should stop the clock and okay.
Yes, yeah, we'll stop the clock so we can allow Mr. Walsh's internet to activate again. I think you're okay, Attorney Walsh. We stopped the clock, so you can go ahead and resume again.
Again, my apologies. But so while I think one of the easiest pathways to dispose of this case is to simply understand that it's not a taking. As a taking, it is construed as a taking. This court is certainly within its ability to provide guidance on what just compensation in the statute should be. But what I don't think should happen, and I don't think the law supports this, is a determination that there would be no mechanism for just compensation at all under the statute, and that the whole thing should be tossed aside as facially unconstitutional. And not only do I think that it passes muster under the just compensation concept. But the question of what a public purpose is, I think Judge Sokola dealt with that quite readily in her decision and order, and found that there was a public purpose. And I think the issue of deference that was raised in the 162.4 square meter case, the issue of deference to legislatures that appear in our brief, I think are important here. Because what Judge Sokola said was, I have reviewed the record, and in the record I find no doubt that there is a public purpose. She cites the legislative history for it. And this deference to the trial court and this deference to the record is clear, is important, because as we see in the case we cited, de Benedictus, even the United States Supreme Court recognizes that in that de Benedictus case, the district court and the Court of Appeals were both convinced of the legislative purposes set forth in the statute, that they were genuine, substantial, and legitimate. And we have, the court sitting in an appellate review, we have no reason to conclude otherwise. And I think the record is clear on that here. We have a Superior Court judge making a factual determination from her review that there is a legitimate public purpose. And not just a legitimate public purpose in any law, but especially in a law that was passed 15-0 and signed by the governor of Guam. And after doing that, the court said, well, I see nothing in the record that's different. And I think this court can make that same determination.
But as Mr. Mann strenuously argued, there needs to be a broad public purpose. And you point out many issues are factors that pertain to a judgment debtor-creditor relationship. And the argument of Mr. Mann is we don't have that dispute in this particular case. Genpro is not a debtor of Western Sales, and they just happen to be in the unfortunate circumstance that they are in a business transaction with a judgment debtor of Western Sales. And so it appears that this statute really just benefits a very narrow group of persons, and there is not this broad public benefit, which is what the public purpose, public use, public benefit, which authorizes the use of a condemnation action in seizing private property.
I'd say two things to that. The first thing I'd say, Mr. Chief Justice, is that what is the broad public purpose? Judgments of this court or the courts of Guam should be respected. Judgment creditors who access the courts of Guam, and there are many of them, should be able to collect on their judgments. So if a debtor continues to avoid the orders of these courts of Guam, I think there's a broad public purpose in making sure that the orders of these courts have carry weight to them, especially when recalcitrant debtors continue to try to access the Guam market. I think I've frozen there again. So in addition to making sure that the orders of these courts are followed, the judgments from the courts of Guam have effect, the second thing I'd offer is Genpro was no, I think, victim of unfortunate circumstance, I think was the phrase that was raised. I'd ask the court to look at our supplemental of excerpts of record at 43 and at 49, where we see that Mr. Bowie of Genpro is not some sort of unfortunate individual who finds himself the victim of some statute. They know Genpro is arm in arm working with 7D, the recalcitrant debtor, to continue to help 7D access the market and avoid its payments to Westfield. The contract that Mr. Mann says has been infringed upon here, that has been incorrectly impaired, that contract is a contract that fathoms litigation. That's a contract that Genpro enters with 7D to specifically make sure that Genpro pays for litigation such as what's going on right now.
But Mr. Walsh, I think it's just as Merriman points out, although that hypothetical may be extreme, that this statute doesn't just benefit bad actors, or it doesn't make a distinction, let me put it this way, between bad actors and good actors. It applies across the board, and that hypothetical of someone walking into Kmart, making a purchase of these dried mangoes, potentially under the scope of the language of the statute, since it doesn't have limitations, it may apply to this innocent third party. And in reference to whether, if there is collusion, if there is a bad actor involved here, there are other remedies available to Western Sales that we may not necessarily resort only to a takings type of case. Tortious interference with a contractual relationship, a conspiracy theory in trying to avoid a judgment in a particular case. So just focusing that the statute is the only remedy that can provide relief to a recalcitrant creditor, debtor, it may be problemsome.
If I could, I'll address Justice Merriman's hypothetical directly. Justice Merriman posed a difficult question of what happens if somebody goes to Kmart and buys dried mangoes, now that they could, but goes to Kmart and buys its dried mangoes. The statute protects procedural and substantive due process rights by the statute allows opportunity to be heard and a noticed hearing. Apologize, I think I froze again. So the statute allows substantive and procedural due process protections. Right? There is a notice to be heard, an opportunity to appear before a judge. So I think if this court's concern is the innocent party, unlike the appellant here, is just some sort of broader issue of an innocent third party, those procedures exist. But again, I'd also point out that there are situations where third parties, as again in a foreclosure situation, could hold title to property and still have their home taken away from them because of the debts of somebody else through a process that happens in our courts. So I do think the protections are there, but I do understand the concern that what about if innocent third party goes to Kmart and buys its goods? But I think, as even Mr. Mann recognized in that hypothetical, it makes no sense for Wesco to do that, because if Wesco were to do that, there wouldn't be any impact to that judgment debt, right? There'd be no reason to seize $10 worth of mangoes, sell them for $10, because there'd simply be no impact to the debt. So I'm not sure a commercially sophisticated litigant or judgment collector would do that. But in this particular situation, I think it's important to remind ourselves that GenPro is not an innocent third party, and GenPro is not bringing an as-applied case to itself. It's bringing a facial challenge to the statute, saying that this statute fails in every regard. And we simply think that that's just not the case, because there are numerous examples we could think of where just compensation would save it. To the public purpose idea, I think there's no doubt that there was a public purpose, or at least that the record shows that there was a public purpose. You're concerned, Mr. Chief Justice, about whether or not there's a broad enough public purpose. I think we are satisfied with that under the statute. It's simply because I think the legislature's determined there is a broad enough public purpose here, because
is there another jurisdiction that has a similar statute than this?
There isn't, Matt. There isn't, Justice Merriman. But Texas, I think, does have a similar statute that allows seizing of assets that are in the possession of third parties. But I don't think that's dispositive on whether or not the statute should pass muster at all, because there are other unique statutes that the Guam legislature.
I really see a distinction where someone holds the property of the debtor and it's taken back to pay the debt, versus it seems to be in this situation, GenPro owned the asset. It had purchased it from, so it isn't like a bank that has a bank account, which we see common in these circumstances, but how do you explain that or deal with that?
Well, I'd first stand upon the idea that the Guam legislature thought this was an important law to pass, right? So even though this court may have its concerns about whether or not this was the best way to do this, I think the legislature spoke 15-0 to do that. And I think that carries significant weight. The other thing I'd offer, Justice Merriman, is that in our insular community on an island of Guam, we have other unique statutes that don't exist elsewhere. I can think of the Guam Ancestral Lands Commission statute, or the Chamorro Land Trust statute, where the unique circumstances of Guam's location and place in the world, Guam's location and its people, means that the Guam legislature has to come out with statutes that are directly targeted to the Guam environment. And I think this recalcitrant debtor statute is something like that. We are an American open market economy where that is almost wholly dependent on outside commerce and suppliers and goods and relationships with suppliers from outside of Guam, including those in some places where collecting on a judgment is quite difficult. So I think that's, the legislature saw that. And I think Judge Sokola importantly recognized that in the record. And I have not seen anything in the record to the counter of that, besides our consternation with it. And I think as the dissenters in the famous Lochner case pointed out, the role of the judiciary is while maybe perhaps having difficulty with the statute, is to simply say whether the statute passes constitutional muster or not. Does it violate a law? And if the law that's being violated here is takings jurisprudence, I just don't think it's there. And again, I think the other easiest way to resolve that is to realize that it's not a taking. You know, Mr. Chief Justice, Justice Camacho, Justice Merriman, there is no offense to the Constitution in this case. There's no offense to the Contracts Clause. There's just compensation being paid. There's a public purpose. The Superior Court of Guam was correct in its well-reasoned decision and order built upon precedent from this court and the United States Supreme Court. And because there's no offense there, the appeal should be denied. And if this court has no further questions, I'll thank the court for allowing the litigants to move forward despite the difficulties of this pandemic and move forward with this electronic means. And I'll end my presentation there.
Thank you, Mr. Walsh. Mr. Mann, you may use your remaining time, and you are recognized.
Thank you, Your Honor. Regarding Western Sales' motion to dismiss on the grounds that the appeal was untimely filed, the trial court issued a final turnover order on October 22, 2019. That order disposed of all issues in this case and was final and was entered on the docket that same day. Jimpro filed its notice of appeal 6 days later on October 28, 2019. Now, it is true that the trial court did not enter a judgment on a separate document under Rule 58. However, under Rule 58B2, the trial court's order of October 22, 2019 became final 150 days later, or on March 21, 2020. Jimpro's notice of appeal, filed on October 28, 2019, was premature, but became effective on March 21, 2020, pursuant to this court's appellate rule 4A2. Now, Western Sales does not actually dispute that result. Its argument is that Jimpro should have appealed the trial court's decision of April 26, 2019. However, that was not a final appealable order by any means. In that order itself, the trial court set an order to show cause hearing for May 30, 2019, and it would have been absurd for Jimpro to appeal while there was an order to show cause still pending in Superior Court. Jimpro had a right under the statute to actually prove its cost in acquiring the dried mango product and receive a lien in that amount. That was done in subsequent proceedings. Only then did the trial court enter a final turnover order on October 22, 2019. The trial court specifically held that its order of April 26, 2019 was not a turnover order because, interestingly, Western Sales had moved for contempt against Jimpro, and the trial court correctly said there's no order in effect to be in contempt of, much less a final order that is appealable. It is based on the structure of the statute itself that the case was not over until the Superior Court issued a final turnover order, which was October 22, 2019. There was no final order before that. It would have been a way futile to try to appeal when we delayed things. An interlocutory appeal, perhaps, but you know, that can actually delay things too if it's denied. This is rather like a trial court issuing summary judgment on the issue of liability and say damages will be determined later. Well, that's not a final appealable judgment until damages are determined, unless one tries to do it via interlocutory. So in any event, this court has jurisdiction. Now, I do want to say that, you know, Jimpro does not claim that it has a right to a guaranteed profit. It does claim it has a right to the market value of the property that is taken, just as a landowner, when the government condemns land for a public purpose, has a right to the fair market value of his or her land, not the landowner's quote cost in acquiring the land recently or years ago. It's not even relevant. So it's not like, well, Jim Crow lost its profit, but that's okay because there's no assurance you're going to get a profit in the first place. Jim Crow doesn't claim that. Jim Crow says, look, we have a right to fair market value, and this is a simple case because fair market value is what we sell to willing buyers of the product, Kmart, and the other retail outlets on Guam. Those are willing buyers. Jim Crows are willing sellers. So we know what market value is, and it sells a product in the ordinary course of its business. And so, unless the court has any further questions, I have no further rebuttal.
Anything further, Justice Merriman and Justice Camacho?
Can I just ask a clarification, CJ?
Yes, please, go ahead.
When you say public purpose, is there a difference in your mind that the statute serves some kind of public purpose and the taking of the mangoes is for public purpose? Are those two different things in your mind, or they're one and the same?
Well, there's two requirements here. I mean, first, just compensation must be paid. And secondly, taking must be for a public purpose. And that's distinct. I mean, you can obviously have a case where there's no doubt the taking is for a public purpose, such as building a road or a school, and the government's taking it, but you're arguing about how much the just compensation is. Or conversely, there could be cases where there's no doubt that just compensation is being paid, as in the Kalo versus City of New London case. I mean, people were not saying that it was not enough payment. They were challenging the taking on the grounds that it was not for public use. And so there are two distinct requirements. And so when I say public purpose, I'm referring to what Jim Crow believes is an insufficient public benefit from this statute, in that it benefits only a narrow class of people. But when the detriment to the general public is added in, well, Jim Crow doesn't have to prove that there's no benefit to the statute whatsoever, but it does believe that the advocate of the statute has got to show that it has a sufficient public benefit to pass constitutional muster, because that's the requirement of taking A's property and giving it to B. That's what the court said. You can't just take A's property and give it to B. You've got to have a good reason and a good public benefit, which we believe is insufficient here.
Thank you. All right. Thank you, Justice Camacho. Thank you, counsels. Our time is up, and we want to thank you for participating in our oral arguments, and hopefully someday soon we will be able to conduct our arguments in our courtroom. And so the court will take the matter under advisement, and this court stands adjourned. And to my colleagues, in 10 minutes, we will gather for our discussion. Thank you.
Thank you.
Okay, thank you.
Thank you, counsel.